On March 7, 2025, a Wells Fargo branch off South Zarzamora on the south side. A bank teller's fraud system flags something wrong with a check, and within minutes, patrol cars are rolling in. A man in a reflective vest is getting into his car in the parking lot. Officers move fast, cuffs go on, and for a moment, they have the wrong person entirely. But somewhere inside that bank, the real suspect is still standing there, and his name is Carlos Perez. What starts as a routine fraud call is about to stretch into hours behind a patrol car window. Hours of questions, waiting, and a legal fight that will hinge on a single, brutal question. When does an investigation cross the line into something else? This is the story of a check, a long afternoon in handcuffs, and a courtroom battle over what voluntary really means.
All right, call your next witness.
State called Zachary McFadden.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, and if you'll state your name for the record.
Officer Zach McFadden.
All right, state, you may proceed.
Officer McFadden, were you on duty on March 7th, 2025?
Yes.
What area were you assigned to?
The south side, South Patrol.
On the south side, were you dispatched to any calls?
Yes.
Where were you dispatched on March 7th, 2025?
To the Wells Fargo Bank off of South Zarzamora.
Okay, prior to arriving to the Wells Fargo on South Zarzamora, did you have any indication what you were being dispatched for?
Yeah, the caller called dispatch indicating that a Hispanic male wearing a reflective vest of some sort was trying to pass a check, and that their fraud systems caught the check and they needed police to arrive there.
When you arrived to the bank, what did you observe?
My partner and I both arrived to the bank, and I observed a Hispanic male wearing a reflective vest in the parking lot, getting ready to leave in a vehicle. And so I went to go detain him, and my partner went inside to talk to the caller. That's when the caller indicated that I had the wrong person in custody, so he was released. Then we took the accurate suspect into custody and began questioning him.
Okay, so on this call, you stated that you had a partner. Were you all in the same patrol unit?
No, two different patrol vehicles.
Okay, who was the handling officer on this case?
I was.
So as the handling officer, were you the officer tasked with investigating the call?
Yes.
Okay, and how did you investigate this call?
First, the suspect we read his Miranda rights. He was advised that he was being detained on reasonable suspicion. We had a fraud case in front of us. I went and talked to the caller, which was the employee at the bank, who stated that their fraud system picked up a possible fraudulent check. Then once we determined the details from the caller, eventually I was able to get in touch with the owner of the check. And then the owner of the check stated that he didn't give consent for the suspect to be using his checks, or he didn't write any checks to that person. And it was from a very old checkbook as well.
Okay, so you stated the suspect was Mirandized. Did you Mirandize the suspect when y'all initially detained him?
No, when he was initially detained, it was my partner that Mirandized him.
Where were you when he was Mirandized?
I was inside the bank talking to the caller, I believe.
Okay. At that point during your investigation, was Mr. Perez under arrest, to your knowledge?
No.
Why?
Carlos Perez wasn't under arrest. Not yet. In the eyes of the law, he was detained, cuffed for officer safety, while investigators tried to make sense of a fraud case that kept shifting under their feet. The check didn't match the account holder's story. The details Perez gave kept changing, and the officers needed someone who wasn't even on shift yet, a fraud detective, before they could move forward. So they waited and waited. What began as a routine stop was turning into something far more complicated. A case built piece by piece, over hours, in the back of a police car, with a man who insisted he understood his rights, but had nowhere else to be.
At that point, we were still gathering evidence, still piecing together this case. It took quite a while to piece it together. So at that point, he was just being detained while we were investigating a crime. At the point that we had probable cause to make an arrest, he was under arrest. But at that point, he was just detained and read him his rights.
When he was initially detained, was he placed into handcuffs?
Yes.
Why was he placed into handcuffs?
That's just for officer safety and for the safety of anyone that we're dealing with. In law enforcement as a whole, but especially on the South Side, we deal with a lot of violent crime, a lot of firearms, a lot of weapons. So we found that both in trial and error and just in a general system of law enforcement, that anytime we leave people out of cuffs, there's a lot of opportunity to use weapons or to assault police. And when that happens, usually to get them into custody causes them to experience bodily harm, us to experience bodily harm, and also puts the public at risk as well for someone evading, someone shooting at us shooting towards somebody. So as a whole, we just put them in handcuffs and then frisk them for weapons.
Okay, perfect. So when you, prior to arriving to a call that you're dispatched to, do you receive information about what you may be coming upon?
Yes, we get our dispatcher over the radio saying that we're headed to the address and the general nature of the call. I think this one was a fraud, was the title of the call, is something like that. Then on our laptop computers in our patrol vehicle, we can see whatever details the call taker is putting on our call screen, where they're talking directly to whoever the caller is, and they're typing out sentences on our computer. If I remember right, an example from this one was a Hispanic male wearing a blue shirt and a reflective vest was trying to pass fraudulent checks at the bank. Then another detail was that he was getting agitated or nervous or something to that extent and was trying to leave. And which kind of led me to detain that one guy in the parking lot, keep him from leaving, because in my mind, got someone matching that description, at least with the reflective vest side of it, and he was trying to pull out of the parking lot.
And on March 7th, 2025, were you equipped with body-worn camera?
Yes.
Officer McFadden, did you have Coban on your patrol unit as well?
We have the mounted cameras on the vehicle. Yeah, I think it's Axon at this point.
Okay.
Yeah, we had the mounted cameras on the vehicle. It's the front and then the prisoner compartment.
Okay, perfect. What do you recognize it as?
It's body-worn camera footage that I reviewed today and then initialed, and then it is also, I believe, footage of the prisoner compartment that I reviewed and initialed as well.
All right, States Exhibit M2 and M3 are admitted without objection for purposes of this hearing.
Thank you, Judge. Permission to publish?
Granted.
Pausing States Exhibit at 22 minutes and 6 seconds. At this time, Officer McFadden, was Mr. Perez under arrest?
No.
No. At this time, to your knowledge, was he already Mirandized?
Yes.
Who Mirandized him?
Officer Chavez.
At this time, did you coerce Mr. Perez to talk to you?
No.
Did you threaten Mr. Perez to talk to you?
No.
Did you promise Mr. Perez anything in exchange to talk with you?
No.
Was Mr. Perez speaking with you voluntarily?
Yes.
At any time, did you tell Mr. Perez he didn't have to talk to you?
I don't recall. I don't remember.
At any point with your interaction with him, did you Mirandize him yourself?
Yes, I believe I was watching body camera footage earlier today and realized I Mirandized him a second time.
Okay.
After I Mirandized him as well as Officer Chavez later.
Why did you Mirandize him?
The length of this call, it was several hours while we were trying to find a detective to handle this case. I like to dot my I's and cross my T's, so to speak. Also, once I felt that we had enough evidence on the table to move towards an arrest, I believe that's about the time frame where I Mirandized him again.
I pass the witness.
All right, defense, you may proceed.
Yes, good afternoon.
Afternoon, sir.
You mentioned that you do some things in terms of guns and keeping people in cuffs, especially in the South Side for safety in general. But in particular, there was nothing aggravating about this call that would necessarily require.
No, it's more of the area. I've worked that area pretty often, the Zarzamora and Southwest Military area. I've dealt with quite a bit of death in that area. When it comes to that Wells Fargo, they regularly have a off-duty police officer stationed over there just because of the prevalent violence and then gun-related activity in the area.
Was there one there that day?
I don't remember.
Mr. Perez, whenever you made contact with him, was actually like very cooperative, right?
Yeah, Mr. Perez was cooperative, was nice, was by all accounts didn't give us any problems or was disrespectful or anything like that to my memory or when I was watching body cam footage today.
And so after Officer Shawway, Miranda, we handed him to you.
Yes, sir. Yeah, just because I was handling, we switched handcuffs so that Officer Shawway could get back in service, and then I placed him in my vehicle. Yes, sir.
It's fair to say that he was in your car for like over 3 hours.
Yeah, and I'm sure that was uncomfortable. And yeah, I wasn't happy about it either. But yes, he was in there for at least multiple hours. I don't know the exact time.
Maybe almost 4 hours.
It's possible. It was a long time. I think if you watch the video footage, you watch it go from daylight to nighttime.
Over the course of all this time, he was never under arrest until the very, very end.
At the point that he was going to be arrested, at the point that he was under arrest and was going to be booked, I advised him of that. After speaking with the detective and allowing the detective to make the final determination, that was when we made the decision he's going to be booked on this offense. I advised Mr. Perez of the decision.
For those 4 hours he was in his car, did you ever offer him water?
I don't recall if I did or not.
I'm surprised you did.
No, I typically don't offer people fruit or water, only because I don't carry it for our folks that we're taking into custody.
Here's where the story turns. Nearly 4 hours in cuffs, no food, no water offered. Daylight fading into night in the back of that patrol car. And then, a detail the defense seizes on. An officer, on his own body camera, floating the idea that this should become an at-large case instead of a custodial one. In other words, even the people running the investigation had questioned whether holding him this long made sense. Was this careful police work chasing down a genuine fraud, or a suspect worn down by a marathon interrogation dressed up as a detainment? That single moment, an officer's own doubt, caught on tape, becomes the crack the defense tries to drive a wedge into.
You typically don't have people in your car for 4 hours.
It depends. If it's a critical incident, we could have people in our car for 6 hours or more. And in those cases, we typically have a lot of resources on scene. And if there's a need to go get food or water, we will. It just went from 1 hour to the next. And keep thinking, we're going to be done in about 15 minutes. We're going to be done in about 15 minutes. And it just kept
He was
going.
sitting in the back of your car all this time and handcuffed.
Yes.
So nothing.
No, he was not free to go. He was detained.
And so basically you just you would talk to him for a bit and leave and come back. So it was basically like a 3-hour interrogation session, right?
For the however many hours it was, he was being questioned after he was read Miranda rights. And so he also advised us both times that he understood his rights, which were read to him. And so, yes, all the questioning that took place was willful on his own end.
At one point, you actually have a conversation with one of your fellow officers where you say, this should probably be an at-large case. Can you say something along those lines?
I don't recall exactly, but yeah, you're reminding me of something. Yeah, that essentially you have a decision to go, we can either arrest on this because we have enough evidence to arrest, or this needs to be pushed to a follow-up unit and they could file at large to issue a warrant for the arrest later.
And the reason I ask you that is because it at least showed an awareness on your part. You're keeping him in custody forever. It's getting kind of unreasonable at this point. So maybe you should let him go and follow up with an at-large case once you have a third investigation.
I would say if there was no progression in the case within those hours, and we were just sitting on the same amount of evidence that we started with, the same amount of knowledge, the same amount of statements, I could definitely agree with a statement like that, especially for the amount of hours we're talking about. But the reality of this one in particular was there was a steady progression, although it was slow and annoying to everybody involved. There was a progression where we had to get a detective because of the nature of the case being fraud, and that does go to a follow-up unit. And we also had to speak with everybody involved, tellers at the bank, the employees of the bank, and then eventually get in touch with the victim, the owner of the checks, and get his statements over the phone. He had a lot of statements to make to me over the phone. And my main thing I was trying to establish was, is anything the suspect saying here credible? Because the facts changed quite a few times, or I'm sorry, the statements he was making changed quite a few times. And I understand that that could be a number of factors.
That's the question.
Oh, I apologize. I'm sorry.
And just one last question. At any point up until the arrest, even though he was sitting in your car in handcuffs, he was not free.
No, he wasn't free to leave.
Never applied.
No.
But you told him that a couple times, that he might be rude.
I told him that, yeah, based off of whatever may occur in my investigation, that he may be free to leave it that day. In my mind, I was going from, first, I need to determine if we even have enough, if there's even been a crime committed. Very oftentimes, we will put people in handcuffs that get released later because there's a lack of evidence. And then in other cases, it's a at-large case. And in both cases, they're released from handcuffs that day and they're walking without ever being booked. So I advise them of the possibilities.
Officer McFadden, you stated that you were waiting on a detective. Why were you waiting on a detective?
We have a lot of follow-up units. Their working hours end at about 4:30 in the afternoon. The unit that deals with fraud cases was getting off at that time. The next major detective unit would be night CID, and they get on at, I believe, 7 p.m., which would be 1900. So there's what's called a gap detective, a detective or a couple of detectives that bridge the gap between the follow-up units and then the night CID detectives. So during that gap, I wasn't able to get either in touch with a detective at all or a detective that was able to handle the case.
At any time, did you allow Mr. Perez out of the car?
Yeah, I believe that we exited the car. I know for sure at least once, because we switched him from a single pair of handcuffs to double handcuffs to give him a greater comfort, a little bit more motion in the shoulders. And I also allowed him the use of his personal cell phone to call work. We don't normally do things like that, but it was a very long situation, and I wanted to give him every opportunity to call work or do whatever he needed to do that wouldn't compromise the case, but would also just recognize him for his human needs and things of that nature.
And at what point did you determine that a crime had been committed sufficient to place Mr. Perez under arrest?
Multiple conflicting statements from the suspect as far as the nature of how he got the check, what the check was for, his relationship to the writer of the check or the owner of the check, the nature of his work, the location that all of this occurred on. There was a lot of conflicting statements that were made by the suspect while I interviewed him. The nail in the coffin, so to speak, was the owner of the check telling me that the numbers on the check numbers at the top, were from quite a long time ago. They were like hundreds of checks off from his current checks being used, and that he did not give effective consent for anyone with the suspect's name to be writing or cashing those checks. And he didn't have anybody matching that description or with that name that had completed work that he claimed to have completed. So it was all of those statements notifying the detective of that, and then the detective determining we're making an arrest.
Regarding Mr. Perez, did you check on him at any point while you were waiting for people to call you back?
Oh, yeah.
Yeah.
Quite a few times.
I pass the witness, Your Honor.
All right. Any other questions from either side?
And from the state, Your Honor.
All right. Is this witness excused for the purpose of this hearing?
Yes, Your Honor.
All right. You may step down. Thank you.
Oh.
All right. Any other witnesses?
None from the state, Your Honor.
All right. Then the court will hear argument. Defense is your motion. You may proceed.
Mr. Trump, I would encourage the court to grant my motion to suppress. The evidence that was shown here shows that he was in custody for a total of 4 hours. He was never offered water at any point. Yes, he was Mirandized beginning, but I don't think it was proper because they didn't have any reasonable suspicion or probable cause to put him into custody, detain him at the beginning. They had nothing. They said he showed up and arrested him. I don't think that was reasonable. He was basically put into custody immediately. I don't see how you can be in a pre-arrest detainment for like 3 hours. That just doesn't seem reasonable to me. They could have proceeded a number of different ways, which they didn't. It's not really his fault that if it was in the South Side, that's what they do, or that they couldn't get a hold of who they needed to get hold of. They put him in the cuffs. They didn't feel like they had enough evidence until like almost 4 hours later. For that reason, I think it was all unreasonably done. And anything he said to them was improper.
Right. So from the court's reviewing of our parties stipulating that Mr. Perez was Mirandized before he gave any statements?
Yes.
Yes.
All right. And do parties both stipulate that the Miranda warnings that were given were the appropriate Miranda warnings?
Words.
Okay.
This is where the case stops being about fraud and starts being about the Constitution. Both sides agree Perez was read his Miranda rights, twice in fact. The real fight is over voluntariness. Can a statement made after hours in handcuffs with no water still count as freely given? The defense argues the setting itself was coercive. A locked patrol car is nothing like a police interview room. The state counters that Perez was let out, recuffed for comfort, allowed to call his job, and checked on repeatedly. The judge doesn't rule from the bench. Instead, he asks for something narrower and more precise, the exact gap in time between each Miranda warning and each statement that followed. It's a reminder that in cases like this, minutes and seconds can matter as much as intent.
So then, defense, your entire issue is whether it was done voluntarily, correct?
Yes, sir.
How are you saying, or your belief that it's not voluntary?
Judge, they did read him his rights initially, but then they held him in custody 3 hours after. Actually, almost 4 hours after. I don't think it's reasonable that if they Mirandized you in the beginning and then they hold you for 8 hours, is that reasonable? And everything you say after that is, and if they have you in handcuffs in the back of a police car, this isn't like your typical type of interrogation that maybe would happen in a conference room with the police department, where a lot of times they don't put people in handcuffs and just talk to them. This is, by definition, like a way more suggestive way to handle it. He was never given water. He was held in handcuffs for 4 hours. They never really gave him a chance.
So are you saying that the evidence presented that he was detained or in handcuffs for 4 hours?
Yes, Your Honor.
And when are you suggesting that the Miranda warnings were given and the statement was made by your client within that 4 hour time period?
The Miranda warnings were given pretty close to the beginning of the 4 hours.
You're saying that it was approximately 3 or 4 hours of him being in handcuffs in the patrol vehicle?
So he was in handcuffs for 4 hours.
Okay. The question the court wants answered, and I'll review the entirety of the videos. What is the length of time between Mr. Perez being Mirandized and the beginning of the statement he's alleged to have given the officer and the ending of the statement that he gave the officer? Does everyone understand what the court is requesting?
And you mean when he doesn't say anything else?
No, just his last statement. For example, I want to know, and I'll watch the video to see, but I'm trying to make sure that you all give me the argument because this is the crux of the issue here. So he's Mirandized, placed in handcuffs in the back of a patrol car, gives a statement. From the time he was Mirandized to the first statement of words he speak, what is the lapse in time? And then what is the lapse in time from the time he was Mirandized to the end of the statement that the state is seeking to have admitted? Those are questions that the court wants answers to because both parties have stipulated that he was Mirandized. So then there are other issues that the court needs to consider to make a ruling on whether or not the statement should be admissible. And those are one of the issues I want addressed. So does anyone know the answer to those questions? Or
if you just give us a couple of minutes, Lauren does have some timestamps. We'll go through them and try to get them to you in a couple of minutes.
All right. And so defense, if you'll review the time steps with them as well. And of course, as I said, I just want to hear your arguments on that point and any other arguments you want to make. But I will most definitely review the videos as well. The court will hear argument. Defense, it's your motion. So now that certain things have been established with regards to Miranda, I'll hear your argument.
Yes, Your Honor. I believe the court asked for some briefing on the timestamps when things happen.
Yes.
First, the video.
So is 7:14 the conclusion of the alleged statements from your client?
I don't see any statements that he made after that.
Okay.
It's about 3 hours.
All right. State.
Your Honor, we would just ask that because he was Mirandized, he agreed to speak, that you find that it is voluntary. He was let out of the vehicle twice during this interaction, and as testimony heard, was that the investigation was progressing. It was just slower. They were during the gap period, and although he wasn't offered water, reasonable accommodations were made for him, such as allowing him out of the vehicle to call work. They allowed him to be double cuffed, which was at 18:14 and 18 seconds. I'm sorry, 18:12 and 12 seconds. And Officer McFadden did check in on him multiple times throughout the time and tried to keep him apprised of what he was doing, such as he's waiting on the detective, trying to get in contact with the proper people. So we would ask that you deny defense's motion.
All right, defense, it's your motion, so I'll allow you final argument.
Yes, Judge, I don't think that this was a reasonable amount of time to have somebody pre-arrest taken. He's kept in the back of the car for at least 3 hours before he was actually put under arrest. There was no safety concerns. There was no other reason for him to be held in cuffs under those conditions. He was not offered water. He was not given anything to accommodate him. I understand there's issues in that part of town, but there's nothing extenuating about this particular case with this particular client. For that reason, I'd ask you to provide a statement.
All right. So what about being allowed access to his cell phone to make phone calls and being allowed out of the vehicle and being double cuffed for more comfort?
I did see him get access to a call with respect to the handcuffs. I believe he did that pretty early.
All right. So what I'm going to do is, if there's no objection by the state or the defense, if you will leave the unredacted versions with the court reporter, I'll review them. And if you all are here tomorrow, well, I shouldn't say if you are here, I would like for all of you to be back here by 1:25, and I'll give you my ruling. We're going on the record. Court is going to call State of Texas versus Carlos Perez. And are you Mr. Perez? All right. So where we left off yesterday is that there was a motion to suppress held outside the presence of the jury. It was related to whether or not the defendant's statements was admissible. I heard arguments from both sides, and then I wanted a chance to view the entirety of the exhibits that were admitted. And the court reviewed those exhibits last night. And this is what the court is finding. The court is finding that the officers were credible and truthful. The court finds that the defendant was handcuffed and placed in the patrol vehicle and read his Miranda rights at approximately 16:55:20, and both parties stipulated that that was the time. Testimony by the officers was that the defendant was not free to leave. Although the officers stated that the defendant was being detained and was not arrested, the court finds that the defendant was in custody. The court is finding that the parties have stipulated that the defendant was read his Miranda warnings at approximately 16:56:01. This was before the defendant made any statements. Although the first officer initially stated that the defendant did not voluntarily waive his Miranda rights, he later revised his testimony and specified that the defendant acknowledged the warnings and voluntarily answered questions. The court thus finds that the defendant freely and voluntarily waived his Miranda rights when he made the statement at 16:56. The court finds that the defendant was transferred to the second police vehicle at 17:03:22. The court finds that the investigation was proceeding very slowly, but the officer's explanation of why it was taking so long was credible. Although the length of the delay regarding the defendant's custody was excessive, the length and conditions of the delay were not so unreasonable as to render his statements involuntary. The court finds that the defendant was not deprived of food or water over an excessively long period of time. The defendant was allowed to use the phone and have his handcuffs adjusted for comfort. and the parties stipulated that the defendant was again read his Miranda warnings at around 19:45. The officer testified that the defendant indicated that he understood his rights and that he waived his Miranda rights. The defendant then made another statement at 19:47:30. The court finds that there is no evidence indicating that the defendant's will was overborne. There is no evidence that the officers threatened or coerced the defendant or offered the defendant any incentive to waive his rights and speak to them. There is no evidence that the defendant was intimidated, compelled, or otherwise coerced into answering the officer's question. This court finds that the defendant made an uncoerced choice to speak with the police. He had the requisite level of comprehension, and thus he waived his Miranda rights. This court finds, therefore, that the second statement was freely and voluntarily given without being coerced. After examining the totality of the circumstances surrounding the interrogation, this court finds that both statements made by the defendant during the entire time period he was in custody were voluntarily and knowingly made.
After reviewing the footage overnight, the judge delivered his ruling. Both of Perez's statements, one shortly after his first Miranda warning, another nearly 2 hours later after a second warning, were found to be voluntary. No threats, no coercion, no promises. The court acknowledged the delay was long, even excessive, but concluded it wasn't unreasonable enough to throw out what Perez had said. It's important to note, this transcript covers only the suppression hearing, the legal fight over whether these statements could be used at all. It is not the final verdict in Carlos Perez's fraud case, and no determination of guilt or innocence has been made here. What it does show is how much can hinge on a handful of minutes, a pair of handcuffs, and the fine print of the law. If you found this case as interesting as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more incredible case breakdowns.